in the law where in such a situation it could be considered as income. That's the first important concept. You need to have a, we always say that you need to have the charging section. Unless there is not a charging section to consider one particular receipt as an income, the question of going beyond that doesn't arise. So there was no charging section as far as Income Tax Act was concerned. That was the fundamental finding which the High Court held. Then the issue was, is it a capital receipt? And I would just like to share where they clearly held that there are series of judgment, and even in Sandhu Brothers, where Supreme Court very clearly held that a capital receipt is not an income under Section 224 unless it is chargeable to tax as a capital gain. And there is no separate section under the capital gain to treat such income as a capital gain. So therefore, they clearly relied upon Supreme Court and said, by any stretch of imagination, anything which you receive on account of capital should not really be treated as a revenue receipt which is subject to chargeability. Further, they also very clearly held that income has to be given a broader meaning. Any transaction you consider and say it is an income, it has to be given a broader meaning to include notional income, or otherwise it is specifically provided in the law. And if you don't do that, it would be rendered, or twice is far stretched. So they strictly, and they very rightly worded so, that you cannot broaden it to and go much beyond that by presuming so many things, and when the law doesn't provide you to go for secondary adjustment. Then the second issue came was, can you tax as notional income? If there is no charging section, you can presume that value should have been not X but Y. Different needs to be considered as a loan. Loan should have been given on the interest. Interest rate would have been at so and so rate. Everything notionally you are computing. And they said that the manner of reading a provision, I would like to read out where they spell out, the manner of reading a provision by ignoring or rejecting words within any finding, that in absence of so rejecting, the provision would become unworkable, is certainly not the permitted mode of interpretation. This rejecting of word in statute to achieve a predetermined objective is not permissible. The officer predetermined that I wanted to tax this transaction, and then he reads the statute. He said the High Court clearly held that that is something which is not, you decide upfront. You read the statute and see what is the interpretation of the statute, and then see whether it is taxable or not. You decide upfront that it is an income, and then you read the statute in your own way by ignoring few sentences here and there, and then you come to the conclusion. That is something which was also not very clearly spelled out. The other issue which came back was also that it was held that arriving at a value of a transaction on the basis of arm's length would not convert non-income to income. When premium is not an income at all, how come you can convert non-income into income? Tax, it could be levied only on an income, and where income does not arise, the point of applying arm's length doesn't arise. How come you can say anything and everything falls under the transfer pricing if at first bit it is not an income? And second, if it is not an income, how can you presume when the law does not permit you to go on a notional income? So interestingly, they came out to be very clear, and then they also spelled out by saying that income has to be likened pictorically to the fruits of a tree or the crop of a field. It is essentially the produce of something which is often loosely spoken as capital. So in a way, they very clearly spelled out that anything which is notionally should not be charged. Further, if you will find that they said it is well settled position in the law that the charge to tax must be found specifically mentioned in the Act. If the Act is silent, you cannot presume and bring anything and everything into the law. I think these are very, very straightforward rulings. So effectively, three things which comes out of this ruling is that if the law does not have any charging section, you cannot bring anything into the income, number one. Number two, if it is not an income at first place, the question of applying transfer pricing rules and regulation does not arise. And thirdly, they said anything which is notionally, which actually is not an income, you cannot presume that it is notionally is your income. They have come out with a very wonderful findings, very strongly, worded. If you will go through this judgment, they have come out very strongly and heavily on the income tax authorities to say that you cannot pick and choose the way you wanted to read the law. You have to go well within the four corners of law, and it appears that you have predetermined that you wanted to levy the tax on this transaction, ignoring how the law is being framed. For your information, premiums are taxed. There is a separate provision for Indian companies. If I am issuing a share at a premium, and the premium according to the tax authority should be 50 rupees and I am charging 70, difference is treated as income from other sources when I am overcharging. But then there is a specific provision only for residents, not for non-residents. Number one. Number two, there is also a law that if the share value should have been 50 and you are charging 30, 20 would be considered as a difference, as a gift, and that gift would also be treated as an income in the hands of the recipient. But that there is a specific provision under the law. Under the transfer pricing, you cannot read the same into this. And this law was brought way back in 2009. And this judgment was pronounced even prior to that. Unless the government will bring in the change to bring such transactions within the ambit of transfer pricing, I think it is practically impossible to do anything within the law to consider such transactions fall within the jurisdiction of transfer pricing. That is the fundamental thing. Secondly, now after this judgment of Vodafone, Shell was also, there are so many other companies who have filed on the same lines. Shell judgment has also come by the Bombay High Court exactly on same lines. And you would have also read that Finance Minister has referred this matter to Attorney General for his opinion that should we really file any SLP in this matter or not? Should we really fight it out or not? I think where the senses of the government will come out very clearly, how would they take a call? But certainly it's in a very good judgment, very well reasoned judgment, very nicely worded judgment, and I don't think that the government would be appropriate to take anything by fighting further in Supreme Court. Thank you.
Thank you, Krishan. Thank you, and I think you make a very valid point here that the appreciation and understanding of the transfer pricing law has taken a long time before some of these judgments have come through, and I think we'll have many more learnings to have before tax system in India becomes far more smooth than what it has been so far. Before I conclude, and I have about 10 minutes time to make my point, I just thought today we are celebrating the Law Day. Maybe it's a good idea to read out the preamble of the Constitution and connect it with what we have been discussing. Quickly, it said, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular democratic republic, and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, faith and belief, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual, unity and integrity of the country, of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give ourselves the Constitution." The question is, has the Constitution failed us or have we failed the Constitution? And this is a very heavy question that I ask, it's not easy to answer. But one thing is very certain, that insofar as taxation is concerned, we have the sweeping caveat within the Constitution, which is Article 265, which says that no tax can be imposed without authority of law. And the problem is, when you have such a hard-hitting statement in the Constitution, the implementation of that is where we actually have serious challenge. The assessing authorities, from where it all begins, the history of litigation in India starts with the assessing authorities. They have the scantest regard for the law. They think they are the law themselves. Their interpretation is often so warped that it takes companies years together to stitch their shirt and make it happen before the Supreme Court. Numerous amounts of rupees and dollars, if you will, is spent trying to justify a very standard interpretation of law which should have been taken by the assessing authority to begin with. But that's the state that we are in. And that kind of folds into the very fundamental concept of this new change that we are looking at, this change of GST, and that is where Mr. Kumar spoke about the Australian experience. But I have my own doubts about how India should be looking at it. You know, the first and foremost canons of taxation, as they say, is the certainty of taxes, right? How can you even imagine about what the GST is going to look like unless the draft legislation is made available to you? Mr. Kumar made a statement, rightly so, that there will be teething transition problems. You will be switching over from one tax law to another. And my problem is that if I do not know what my legislation looks like, how it reads, how the nuances are stitched in, because the devil lies in the detail, how do I even plan and order it myself? It would have been very proper for the government to have taken the stakeholders not only in private conversations with the industry chambers that they often do, but also to have floated the draft legislation for people's consumption so that they could have come out with their feedback. It is very, very important. Else what will happen is what we did when we migrated from sales tax to VAT. On 31st of March 2004, and I still remember that night, my clients kept calling me and saying that, look, from tomorrow onwards we have VAT, what must I do? And I said, look, I don't know. The state has just about come out with the legislation at 11:55 p.m. and 12 o'clock you're calling me and I don't know because I haven't even read the law. I don't even know when the rules will come out, and mind you, the rules came out on 15th of April. So there was a huge gap because they were in a rush to make it happen and they didn't realize that in this whole process businesses were suffering because continuity of business is probably the most fundamental thing that every industry wants. And you cannot have a disruptive system being introduced without taking the stakeholders' confidence. That's point one. Point two, very, very critical. What we're talking about is a very, very bastardized version of GST. And I'm sorry to use that word, and I say that with a lot of pain. Not because India doesn't want to follow what the Australians have done, or what the Canadians have done, or what the New Zealand people have done, or the UK has done. It's because we have a very different fabric of the nation in as much as you have the states that are sovereign insofar as their activities are concerned, and you have the central government that is sovereign insofar as they are concerned. The separation of power is one of the fundamental principles of a constitution, which means that you cannot invade into the state's proprietary and the center cannot, and the state cannot invade into the center's proprietary. And if you're talking about a GST, it basically means a unification of taxes of the state and the central level. The question is, it's a tug of war between the states insofar as what they will forego and for whom. So today the states have the sovereignty to levy sales tax. They have sovereignty to levy local taxes by whatever name called, whether it is entry tax, whether it is other municipal taxes. The central has sovereignty of so far as excise duty is concerned and service taxes are concerned, income taxes are concerned, and the state runs on the revenue that it generates from its sales tax. And if you're asking the states to forego that power or share that power with the central government, you're talking about trouble. Because no money, no state machinery can function, no state machinery will be able to get paid. Therefore, the larger issue that the states are grappling with is that, okay, fine, if I were to migrate from this system to the new system, what kind of compensation do I need to have from the central government? Because GST, given a choice, they probably do not want to get into GST. So it's a carrot and stick policy that is happening from the central government, and the governments are trying hard, and it will take some time before they can actually convince each other that, look, if you were to get into GST, ABC are the benefits, and the losses that you're estimating is going to be so many $1 million, so many million rupees, or whatever it is, I'm going to compensate you. So until that compensation is agreed between the states, nothing much is going to move. And that is a political issue more than anything else. Because now with the change of regime in the central government and now the increasing states being governed by the same government, same party which is at the center, things may ease off. But in the prior regime, there was a deadlock because you had the larger party at the central government different from what was happening in the state level. So that's one. Second is, if you're asking about a combination of taxing power between the state and center, you're talking about some very fundamental constitutional changes. Constitutional changes in as much as the proprietary under entry 54, list 2, and therefore 92C, 97, various other list 1 entries that we're talking about, they will have to go through a merger. And that means a fundamental constitutional shift, which means that you have to take the states into confidence and make a constitutional amendment happen. And the constitutional amendment bill has been lying for the last maybe 2 years now. And this winter session, I'm hoping that the constitutional amendment bill will get passed. And if it doesn't, God save you, because then we are talking about another deferral until the budget session happens. So this constitutional amendment bill is very, very fundamental. Until that happens, GST is going to be a dream that might just come true should we exist in the next 3-4 years, so to say. The third, equally important, is We are talking about marriage of mind between the central revenue officers and the state revenue officers. The state revenue officers have never dealt with the concept of manufacture, never dealt with the concept of import, never dealt with the concept of reverse charge, never dealt with the concept of services. They've only dealt with sale of goods and sale of goods alone. Vice versa, the central revenue authorities have never dealt with sale of goods. They have no idea about how sale of goods happen and what are the commercials that goes into it, what kind of deductions do happen and so on and so forth. So you're asking different revenue authorities to merge their thinking process and look at GST and in a very unified way. It's a tall order. If the state machineries and the revenue officers across the length and breadth of the company and of the country are not prepared enough, we are staring at a real serious difficulty. Unlike most other countries, be it Australia or be it the UK or the European Union, you had only one revenue officer. The commissioner of taxes there or HMRC, whichever name you may call it, they all knew about one taxation that operated, and it's just a shift in thinking, that's all. Here we are talking about two different sets of people, people who played cricket to be knowing about football and people who played football to be knowing about cricket. That's a huge tall order thing. That's the third point. Fourth is about why do we want GST? The whole avowed reason why we want GST is expectantly to create a buoyancy in the economy, to come out with this parallel economy, to make sure that businesses don't pay taxes, that taxes are to be consumed, the taxes to be paid by the consumer and so on and so forth. But it will not work if the legislative framework does not have a convergence. And I say that with emphatic statement because what we will have is a two-tier GST in our country. We will have a central GST and we'll have a state GST. Now, if the legislative provisions of the state GST across 25 states that we have do not look alike, do not read alike, do not get implemented alike, we are once again talking about a multiple tax jurisdiction within the country. That would be the death knell. We also therefore need not only a congruence between the legislative provisions across the various states in the country, we also need a congruence qua the central government as well. And if that congruence is missing, if the convergence is missing, then we are looking at a mayhem in the market. And the more important thing, the whole GST system is based on the edifice